Let me welcome you to XReg's webinar on the proposed markets in crypto assets regulation.
Hello, everyone. So in addition to the key requirements for all offerings, issuers of stablecoins will have to comply with additional requirements. First of all, the issuer of a stablecoin will have to be authorized in a member state in the EU, either being established and authorized or registered and authorized. There's some differences between asset reference tokens and e-money tokens. And secondly, their white papers must be pre-approved prior to any offerings taking place. The white paper, as Sean mentioned, and some of you will know, is an information document that contains specific required information, such as key characteristics on the issuer, a detailed description of the crypto assets that are being offered, terms and conditions, and highlighting any risks wherever appropriate. In the case of asset reference tokens, these issuers must be established in the European Union and, again, authorized by a regulator there. And whenever the asset reference tokens being offered are used as a means of payment, they will be subject to provisions in the Payment Services Directive, which is a long-standing piece of legislation in the EU. Issuers of asset reference tokens will have to grant their holders with minimum rights also. E-money tokens have been defined as e-money, which means that they will need to comply with all the rules and requirements under the e-money directive, which is again another long-standing piece of legislation in Europe. It's been around for about 20 years. These tokens can only be issued by either credit institutions or e-money institutions. Credit institutions are essentially banks, and e-money institutions are businesses that have been licensed as an e-money institution under the e-money directive. So entities, a financial services entity that's already authorized under the EMD. These types of tokens must be issued immediately on receipt of the funds and must be redeemable on demand. In both cases at par. So if an e-money token is referencing €1, it will have to be redeemable, at €1. As Sean mentioned in the previous slide, both asset reference tokens and e-money tokens may be deemed as significant. In these cases, they will be subject to a lot more stringent rules. Their supervision will be the responsibility of the European Banking Authority. So they won't be supervised by the regulator that authorizes them, rather by the European Banking Authority. And they will have to comply with more onerous requirements, for example, higher capital requirements, specific liquidity and interoperability requirements, and other. If we could move to the next slide, please, Sean. Crypto asset service providers have been broadly defined as any person whose occupation or business is the provision of crypto asset services to third parties. In essence, anyone that is providing a crypto asset service by way of business. Crypto asset services have also been broadly defined by specific activities, the first of which is custody and administration services. Custody and administration is the safekeeping or controlling of crypto assets or the means of accessing these assets on behalf of someone else. So custodian wallet providers would be captured by this service. Exchanges that facilitate either crypto for fiat or crypto for crypto exchanges will be captured by by the second service defined in the regulation. Operating a trading platform is basically the management of a trading platform for crypto assets, where third parties can buy and sell interests for crypto assets. The execution of orders, both for crypto assets and more specifically for asset reference tokens, is the concluding of agreements of the buy, sell, or subscription for crypto assets on behalf of someone else. And reception and transmission is the receipt of an instruction by another person to buy, sell, or subscribe for crypto assets, and then the transmission of this order for execution by someone else. The provision of advice has been defined as either personalized or specific advice that is given either at the request of a third party who might be a client or at your own initiative for the acquisition or sale of crypto assets. This definition does not seem to include generalized recommendations. And lastly, payment transactions involving asset reference tokens is defined as a service. And this is basically the transferring of asset reference tokens between accounts on behalf of third parties. Moving on to key requirements. Crypto asset service providers, similar to issuers, must be a legal entity and must be registered in the EU. Normally, this would be a company or a foundation, perhaps, in some countries, or other types of legal entities. Crypto asset service providers must be authorized. They are not allowed to provide any crypto asset services unless they've been authorized as a CASP under this regulation. So, for example, a company in Polish, a Polish company, will need to be authorized by the Polish regulator. In cases where they are making payment transactions with crypto assets, they will also need to be authorized as a payment institution. And they will be subject to other requirements, such as prudential requirements, which are essentially minimum capital requirements and solvency requirements, etc., and organizational requirements. These include that the management and senior management of the CASP has to be fit and proper, which means that they will have the set of skills and experience to carry out their role properly. And other requirements are having in place a business continuity plan, complaint handling processes, and other of the more standard requirements for financial institutions. Just quickly going back to the second key requirement, that crypto asset service providers must be authorized. In the case of banks, e-money institutions, and payment institutions, these entities will not require a separate authorization under this regulation. They will be allowed to carry some or all of the crypto asset services and will need to comply with some operational requirements in this regulation, but won't require a separate authorization. I will hand back to Sean, who will touch on applicability, implications, and next steps.
We will be issuing a detailed paper over the next week or so on MiCA. If you'd like to get a pre-release of this document or any other future publications or invites to webinars that we may issue, please feel free to subscribe on via the URL which is on the slide.